Welcome to this introduction to environmental law in Queensland. My name is Chris McGrath, and thanks Alex and EIANZ for inviting me to speak to you. And can I say straight off that this seminar is really aimed at early career environmental professionals, not environmental lawyers. Tonight I'm really covering less than 1% of the sort of content material that I would cover in an introductory course on environmental law. So really the hard question I've had is, what do I actually cover that's useful for you, that gives you something to take away? Because I always think that these after-work seminars, the best thing is when you're sitting there and everyone's thinking, what can I take and apply at my desk tomorrow? And if I can answer that for you, then it's been a good seminar. And if it sort of drifts off into esoteric stuff, then I typically think these after-work seminars really miss the mark. So I've really been thinking of, what can I give you, whatever level you're at, because I know that there's some people who haven't really worked in the system, and then there are some that have. So we've got some town planners and other consultants, so you're familiar with the development assessment system or the mining system. You've already got a fairly complex knowledge. So I'm trying to bridge between people without knowledge of the system as well as people who've already got a fairly advanced understanding. So what can I give you? And so just as a general reference, I've got a website that's got some lectures, more detailed lectures on things like the Environmental Protection Act, the EPBC Act. I did an introduction to government in Australia. It was really aimed at international students, because at the University of Queensland we used to get a lot of students from overseas, and everyone would all the lecturers would assume that people understood, a system of government in Australia, and a lot of students struggle with it. So it goes for an hour, but it's aimed at, if you're unfamiliar with government. I'm just going to step over all of that stuff and really dive into a couple of topics. And I really want to focus on a couple of basic things, and I'll tell you why. And it relates to I was listening years ago to a tennis broadcast, and I remember the presenter saying, champions do the basics well. And don't remember what match it was, anything else about it, but I remember that statement. And I've thought about it a lot as a lawyer and as a professional, because if you think about it, it's absolutely right. You as a professional have to do the basics well before you can go on to the advanced stuff. Because if you don't do the basics well, like in tennis, like Roger Federer, if he didn't, say, do forehand and backhand equally really well, then if he did backhand really poorly, then his opponents would quickly work that out, and soon all he would be returning would be backhand. No one would shoot across to his forehand because they knew that was his strong side. So he's got to do all the basics really well, and then he puts that together into a whole heap of tactics and the advanced stuff. But just as a champion has to do the basics well, you as an environmental professional need to do the basics well. So thinking about two things that I think are really useful to focus on, I want to focus on these two things. How do you think about conceptualize environmental law? And then secondly, the basics of statutory interpretation, which is the core skill that you need to navigate the environmental legal system. And it's sort of like that old adage of, teach a person or give a person a fish and feed them for a day, teach them to fish and feed them for a lifetime. So you learn the principles of statutory interpretation, it's like learning to fish. You can go and look up the legislation yourself. So I'm going to, within those two topics, I'm going to frame it within a real world problem, because my style of teaching, I always start with problems and then go on to ask, how do we solve the problem? And so I'm going to look at a big dam that's proposed, has just been approved in Queensland, the Nathan Dam, and then ask questions like, well, what laws regulate this activity and what applications are needed to gain approval? Which are the real questions that you ask as an environmental professional. So problem-based learning is deliberate, both to make it interesting, but also because you as an environmental professional, you have to be a good problem solver. That's what people pay you money to do. If you can't solve their problems, no one wants to come and hear about the theory of your discipline. Just like if you go to a doctor and you've got a headache and a fever, you don't want to be told about all the theories of infectious diseases or the like, you want them to identify what's making you sick and help you to get well. The same with you as an environmental professional. People come to you to solve their problems. So I also think that problem solving in terms of a seminar like this actually makes it a lot more interesting, because I admit that I lived through a law degree that almost killed me. And I remember I did science and law, and I just remember the science lectures as being so interesting, and the law lectures, honestly, you could have taken me outside and shot me and I would have preferred it. There were so many lectures that were just so abstract and just boring that I just really disliked the law degree. And then what surprised me was when I started working as a lawyer, I found law so interesting, and I worked out what the difference was when you're actually, often as a law student, the law is taught in the abstract, and honestly, all law is boring, I say, until you try and apply it to solve a problem. And that's when it becomes really interesting. So working as a lawyer, administrative law or principles of evidence or something like that, if it helps you win a case or solve the problem for your client, all of that seemingly esoteric stuff becomes really interesting, because there's real world problems on the line, real world consequences for your client. So with that background, let's think about a problem. And I thought about some different problems, and there were some complex ones I considered, but ultimately I went with this one, which is a fairly basic but I think useful one. It's a problem about a dam. So let's think we are in a consultancy and we're giving advice to a proponent for a large dam. It's called the Nathan Dam, and this is where it's proposed. Can you guys see that? So that's the Fitzroy Basin, and the Nathan Dam is down in the south of the Fitzroy Basin, so just there in the southern section. So this was just a orthotopic map, I think, orthophoto of the concept design with the catchment. So it's on the Dawson River. The Dawson River flows east at that point, then it flows north and joins the Fitzroy and flows out at Rockhampton. So there's a couple of weirs already built on the river, and so this is just Google Earth tilting it. You can see I've marked there just the proposed side of the dam wall, and then you can see further upstream, that's one of the weirs. So this is an artist's impression of at least what the first version of the dam looked like. And the first version of the dam, which was proposed in 2003, was put forward by the state government for the express purpose of providing water to allow the expansion of irrigated agriculture, particularly cotton, in the downstream catchment. And one of the issues that was raised by groups that were concerned about the impacts of the dam was the impact of pollution or spray drift from the farms then contaminating the water and flowing out and impacting on the Great Barrier Reef. So here's just a couple of pictures of it's a pretty bad site for a dam, flat, and a lot of evaporation will occur from. This is just the site of where the actual dam wall is proposed. So if we think about this problem, we've got a dam. I think I've got a picture there of Somerset Dam. So we're acting for the dam builder. It's a state government, Sunwater, let's just say, is the proponent. We're acting for them. They're a state government-owned corporation, and they want to build the dam and operate it. That's all they're doing. They're not going to do the farming. They will supply the water. It will travel downstream in the river. People and farmers will extract it using pumps and then grow their crops. And those farmers are the ones that will spray the crops, and that's where the pollution will come from. And then the pollution gets back into the river and flows out to the Great Barrier Reef. So, question for us, should we be responsible for that pollution? When I say we, I mean our client. Should our client be responsible for providing water that others use, that they then contaminate the water? Is that an impact of our project? Is it something that should be assessed when our project is being assessed since we're not doing the farming. But we say that our dam is for that farming. Okay, so that's the factual context. I don't really want to go any deeper into it than that. Want to focus on the law and then unpacking the laws that apply to it and how we think through them. So, to me, when you've got a problem, you're a consultant, you've got a problem, your basic question is, well, does the proposed dam or development comply with the law? Because if it complies with the law already, you don't need any approvals, then you can just go ahead and do it. So, for instance, say, tonight, you go home, you live in a house. Who lives in a house? Who lives in units? Okay, let's just say wherever you live, you invite some friends over and they have a party and lots of noise is generated. Do you need any approval for that? So that's a basic question that you might ask in that sort of situation. Or if you want to do work to your house or to your units, do you need approval for that? So it applies to from you as on an individual level day to day, all the way through to large developments. So I'm sure you can all guess that there's going to be some approval for this, okay? Massive dam, big river, there's got to be some approval. Because the basic way our legal system works is we prohibit activities unless they're approved. So I'll say that again, the basic way that our system works, all of our major licensing systems, is you prohibit an activity absolutely unless you've got approval. And if you've got approval, it's lawful, and you can go ahead and do it in accordance with conditions. That's the basic mechanism that we use. So what laws regulate this and what applications are needed to gain government approval? They're your basic questions that you need to answer in looking at a problem like this. Okay, so can I deal then with this first broad topic? So we're thinking about this dam, but how do we conceptualize the overall legal system? What laws apply to it? So I'd suggest there's three main ways, and I just added a fourth. Actually, on the way here, I was thinking, well, there's really a fourth as well. So I added this in just before I started. So the three main ways that I think people think about, well, it's really the first two that people think about the law, and probably the fourth. So the first one is government or departmental silos. So you see them all the time. You go onto any website, like there's this great website I'm sure many people are familiar with for the planning system in Queensland. Really good website, well constructed, lots of information, huge amount of detailed information. But you look there for links to, say, fisheries laws or ozone depletion laws or any range of other things other than planning, and you won't find them. So I actually learnt, when I started my career, I worked for the Department of Environment up in Townsville. And you experience it when you work for a government department, because you become very good at your laws. You deal with them all the time, you're very good at them, you know where the information is. But if people ask you, even if they're, like I was working for the state government, they would ask questions about, do we need local government approval? And we would simply say, you need to go and talk to local government about that. We won't give you any advice on any other laws that anyone else administers because, well, A, you're worried about liability, and it's not your area and you don't want to tread on anyone else's toes. But the default response from most government people is, we can't tell you about anything other than our own laws, and even telling you about our own laws is actually often they're reluctant to do that because of liability issues. So it's often just, you work it out. Here's the application form, you work it out. So the websites, I could have picked any website, Brisbane City Council, great website, huge amount of information on the Brisbane City Council planning scheme and all that stuff. But where are the links to other bits? You won't find them. Once you know where to find it, they're great to use. But these silos, they're very much how government thinks. So if you're interacting as a consultant with government, that's my experience. Does anyone have a different experience from government? Has anyone found a government department that is happy to tell you about things that they don't administer? No, they just don't do it. So when you are interacting, got some people here who work for government, and I'm not criticising government. I've worked in that system, and I understand why you don't give advice on what laws apply. But at the same time, it's really frustrating for proponents, particularly for, if you're a consultant and you work in the system, you get used to it. But, for a private developer who hasn't paid, $10,000 to a planning consultancy to go and do their DA or whatever, the planning consultancy wants to charge them. If you just want to do your own development application, good luck to you, working out what you need to do. So, silos is a real way of thinking about the legal system, and it's very prevalent, and you as a consultant need to be aware of it because you will face it all the time. Not saying it's necessarily bad, it's just reality. Sort of like, just reality. Another common way of thinking about the law you'll see in really any textbook you pick up on environmental law, the ones that try and explain it. So I've just grabbed a couple here from my shelf. So Australian Environmental Law by Doug Fisher, Environmental Law in Australia, Jerry Bates, which is the standard sort of textbook on environmental law in Australia. And then, there's any other Australian climate law. Here's just some covers, climate change, Australian water law, marine resources management, coastal marine law. All of these, so that you can see with the coastal and marine law, you can tell what they're talking about. With environmental law, if you actually go and look at the contents pages, you'll see chapters on biodiversity, chapters on climate change, maybe a chapter on planning. You'll find they structure their whole communication in around what I call traditional categories, like pollution control, like planning, like biodiversity, like climate change or fisheries. Now, the problem, so traditional categories are widely used, and they're, in my experience, good for explaining at a simplistic level the different parts of the law. So I've written, like I wrote a community education stuff. You might, you'd have a section on planning and development, a section on mining. So I use the categories myself, but you only get away with them at a really simplistic level because the categories break down really quickly. Modern environmental laws are just so widely applicable that things like the Commonwealth EPBC Act or, say, environmental harm under our State Environmental Protection Act, you can cause environmental harm by clearing trees, so vegetation clearing offences. You can cause environmental harm by fishing. You could cause it by polluting. You could cause it by digging up something and allowing erosion. There's all these different ways you can cause environmental harm. You can cause environmental harm by, say, carrying out a large mine, so mining activity. You can cause environmental harm by, clearing land and subdividing it and building houses on it because you've removed all of the forest. So all of these different activities cause environmental harm. They're all potentially regulated under the Environmental Protection Act, or at least you need some approval that avoids you committing an offence against that act. So where would you put the Environmental Protection Act? Would you put it in pollution control? Would you put it in town planning? Would you put it in biodiversity conservation? Well, you'd really have to put it in every category. And once you do put it in every category, then the categories are pretty well useless. So you need to be aware of categories because they're commonly used. At the same time, they're too simplistic to actually be helpful. Now, the amorphous approach, I was just thinking about it. The amorphous approach, I think, builds on categories because most people get taught in this way. But then the amorphous approach is you realise pretty quickly that they don't work, and say as a lawyer you just get to learn the relevant bits. So if you work in the planning system, you get to learn the relevant bits of the planning framework, and then when you've got a problem you just identify those bits. So that's okay to an extent, but what I've done, and Alex, did we get those handouts? Yeah. So I've circulated a handout, and I just I just finished it today. I've been meaning to update it for a few years. And Alex will send it out to you. It only got finished like a couple of hours ago. There's a 6th edition of a little book I wrote years ago that I'd been wanting to update, and this seminar was a really good excuse to do it. So I'll email it out to you, but essentially what it is that diagram. I know you can't read that up the back, but I've given you the diagram on your handout. So essentially this book is explains the environmental legal system in 4 layers: international law, Commonwealth environmental laws, state environmental laws, and then the common law, including native title. And can I just give you an example of sort of one of the let's just choose, say, something short and simple. So I'll just go with the so Biological Control Act. Let's just choose that as a random, really short. So what I've tried to do with this book is actually make it deliberately short. It's just meant to be a brief reference that someone can flick through in half an hour, get an overall idea about all the different bits that are out there, and then hopefully give you a map. So that handout you've got is, I know I've had colleagues who say they find it useful just to put it up in their workstation or something like that, and then you can scribble on it or whatever. And it's meant as a reference point, and what I've tried to do is identify who administers the Act and then find the best website for it. So it's sort of like a map that you can go into, and I'll send you the electronic. We'll send you the electronic version, so you can just use the hyperlinks if you want. And so a short description of what the Act does, but not trying to give a detailed explanation. And go into a little bit more for the Planning Act, Environmental Protection Act, and a few others. But yeah, basically, you can see then the best website that I could find for it, because then if you can then go and get a heap more information on it if you know where to look. So that's hopefully a useful resource for you. So that handout, and it's got the international legal system and the like at the top, and a brief introduction. And I've said on the I won't go on about that. I'll go back to the slides. So that book hopefully is a useful reference for you, particularly to just go out to the different websites. But how I've structured it is just to do these layers and then arrange the legislation in alphabetical order so that it's deliberately avoiding categories, but still giving you some structure, because the amorphous approach, the problem is, there's just so much out there, and, it's just cluttered and not very helpful to you. So hopefully this is a useful approach. So international environmental law is obviously not directly relevant to us, but very important for then, through our system of constitutional law, enlivening the Commonwealth's powers to make laws. And that then is what breathes really life into much of the Commonwealth's environmental powers. So that's where most of the triggers in the EPBC Act come from, is from international law. And then obviously at a state level, we've got a whole range of laws that often apply in really complicated ways. So there are some major ones like the Planning Act, the Environmental Protection Act, and the like, that when you're working in industry, you deal with all the time. But hopefully this is also a useful reference for the not so common ones. And just also I often would say to students when I was teaching domestic environmental law, it's, you might do 50 applications with just state laws, but then there'll be one that, is next to a Ramsar wetland or something that has a Commonwealth trigger, and you need to have a little flag that pops up in your head that, you're aware of other legislation, even if you don't deal with it that commonly, because they're landmines that can go off. Any questions on that structure? Okay, I hope it's useful for you, and I hope that handout is useful for you in the book as well. I know that many people here expert in different areas, could I ask that you have a look at it? And if you think there's a better website that I haven't identified, or there's something that you think can be better explained, I'd love to hear from you, because what I find, one of the hardest things in trying to explain the law to other people is working out what people commonly don't know and the questions they ask. You know, when you're working in an area, you just become used to all of the bits, but trying to explain it to others is challenging. So I'd love for you to look at whatever sections or whatever acts you're familiar with, and send us an email if you think the summary is good, or there are other things that you would add, but with remembering that the intention is for it to be deliberately short. So with that sort of structure, what I like about it is, for problem solving, it frees you up to then just identify the relevant bits and bring them into your problem solving, and identify for your clients, you know, potential issues, and for you to be also comfortable with you know, the overall scheme, that you're aware of all the major bits that are out there. Okay, so as a broad summary, there's 3 basic rules. So moving beyond that structure, there's 3 basic rules for complying with environmental laws. The first is obtain and comply with any necessary license or government approval. The second is comply with any relevant standard imposed by the law, including taking all reasonable and practical measures to prevent or minimise harm. That's the general environmental duty in the Environmental Protection Act. The third one very rarely crops up, but basically you're supposed to, virtually no one does, but if unlawful material or serious environmental harm occurs, you're supposed to notify DES, the Department of Environment and Science, under the Environmental Protection Act. It's the first one that's, you know, where the bulk of work is for consultants. You have to obtain and comply with any necessary approval. That's easy to say. The hard thing is to know what approvals you need and then to comply with them, because they can be long and complex. So a lot of work for you guys as consultants is, you know, once approval is obtained, how do you meet the conditions of approval? You know, monitoring, reporting, whatever it is. You know, you might be tasked to deliver on what the conditions require. So that first one is really where the bulk of work is. So if we think about our dam, there's a whole range of laws that actually do apply to it, but the major ones that I just wanted to touch on, one at a Commonwealth level, the EPBC Act, and then at a state level there's the Water Act, and also the State Development and Public Works Organisation Act, and there'd be Planning Act approvals and a range of other things for it. But the State Development and Public Works Organisation Act kicks in because, sure, virtually everyone's aware, it's set up, there's a Coordinator General set up to essentially facilitate large projects. So if you're a proponent for a large project, you can go to the Coordinator General and they're there to essentially help you get your approvals through. So it can be a very useful component of your application process is to engage that. So for a large project like this, you'd be thinking, can we get it declared a coordinated project? We're acting for a government-owned corporation, so yes, it's not going to be hard. It's the state government wants to build it, so the Coordinator General is going to say yes. In this case, the Coordinator General did say yes for it being a coordinated project. It was the original one was applied for back in 2003, 2004. So they're just some major bits. I want to just focus on the EPBC Act, and I often say, the EPBC Act isn't where the bulk of work is in our industry, because it's so rarely do people actually make applications under it. There's only about 50 referrals from Queensland a year. Compared to that, there's about 23,000 development applications a year under the planning system. So, the bulk of work is in the planning system. But the EPBC Act, I want to just use for the purposes of this seminar, because it gives us some simple things and it links into some broader principles about environmental impact assessment. So if we just are asking the question, do we need approval under the EPBC Act? Well, you can go and, we're really asking a question about, does the law apply? And as soon as we're asking that question, we're doing statutory interpretation. And I often think that to people who don't have legal training, interpreting statutes can often seem like black magic. The answer seems to come from lawyers burning incense and chanting abracadabra. And lawyers can feel that feeling of inferiority. I remember years ago, before I was a lawyer, being told, you know, what do you know? You're not a lawyer. And I worked for the department. That's a legal matter. And, you know, some lawyers can do that. I think that that's really poor, that, you know, lawyers should involve particularly the client and everyone in understanding. And if you're working for a government department, the people who are doing the application, you know, they should understand what the law requires of them, and you can explain them, and they often have valuable insights into, you know, like if you're dealing with a planner from Gold Coast City Council or something, they know a hell of a lot about their planning scheme, more than you will ever know. Engage them and use them. And textbooks, often long and thick, and often focus on complex appellate cases. But if you think about statutory interpretation as only something that lawyers can do, I think that's really wrong. It's largely a misunderstanding of the basics. And a key message that I want to give you in the second part of the seminar is a central challenge you face in your careers as environmental professionals from the law is the ability to navigate multiple large overlapping acts and related documents at the same time. You are typically doing that. So if you're a town planner and you're dealing with a planning scheme, you are doing statutory interpretation using the Planning Act, using the regulations, and using, you know, if it's a Gold Coast or Brisbane City planning scheme, it's this massive document, and you really have to be able to move across it and be between those different documents. And if you can't do that, you can't do your job. So there's often multiple levels of government and decision makers, and you often have to bridge transitions between old and new laws with related documents. So under the planning scheme, or the planning framework at the moment, obviously the Planning Act just started in 2016. All of the there's no new planning schemes out there. Has any councils created a new planning scheme? Olivia? No, so none have. So there's no planning schemes in Queensland that yet use the new categories that the new Planning Act uses. So you've got to use the transitional provisions in the Planning Act to basically bring in, you know, what does exempt development mean and the like, self-assessable development, which aren't used in the new schemes, aren't used under the Planning Act, but were used under the old system. And those planning schemes will be around probably for another decade. So I often give the analogy that, you know, governments say they're going to simplify planning laws. I think every government for the last 20 years has said they're going to simplify the planning framework. The reality is old planning laws never die. They never actually go away, because you have all of these plans and approvals that still need to be dealt with. And so a new planning regime is really just like a cake. We're just adding another layer to the cake. So when you work in the system, you've actually got to understand the earlier systems as well as the new system. It never actually becomes any easier. So, just mention too, related documents for statutes can include a whole heap of things: regulations, regional plans, planning schemes, planning scheme policies, development permits, environmental authorities, and there's some non-statutory documents as well that can kick in. So there's a whole range of things that you need to essentially be able to bring in and work across. So the vast majority of statutory interpretation, though, all it really requires you to do is the ability and willingness to locate and read, often large documents, follow cross-references in them, like go and have a look at the dictionary. When you're reading a section, you know, there's this word, is it defined? And come back and interpret the section. And then think logically about what they say and apply this to the facts. And if you do those few things, you actually should get the right answer most of the time. And you need to develop the confidence to do that. So I've given you another handout. If you pull that out, it should be double-sided. I know you can't read it up the back, so that's why I've given it to you in a handout, but essentially it's got 3 steps. So the first step is you've got to find the statute in force at the time relevant to your problem and any related documents. When I say that, if you are looking at, say you want to do a development application now, then you have to look at the Planning Act, and let's just say it's in Brisbane, then you're going to look at the current planning regulations and the current, was it 2014 Brisbane City Plan. So they're going to be your 3 main documents. But if you were dealing with a development application that was lodged in 2014 and is still kicking around, then obviously you're back under the old Sustainable Planning Act, is it? Yep, Sustainable Planning Act 2011, yeah. So I haven't got the timelines wrong. Sustainable Planning Act and, probably the previous Brisbane City Plan. So, you've got to identify the documents relevant to the time of your problem. That's step one. Then, if you're unfamiliar with the statute, skim read it and identify the parts relevant to your problem. And then third, interpret those parts according to their ordinary meaning. So, can I just explain why I say those 3 steps will solve most of your problems? I know this table looks complicated. It comes from some research I did a few years ago. It was published about essentially what I was looking at. I was really interested into, a few years ago, a report came out from the Local Government and Planning Ministers Council, the first national report on development assessment performance. And what they did was they gave, see the 2 columns on the left by state, and then they gave the total number of development applications in each state. And then they gave the number of reviews, so that next column, they gave how many reviews there were in the state. And it was the first, and I think the only report nationally that actually looked at that. Because when you work in the planning system, like if you're a lawyer, we're typically involved at the litigation stage when it gets into the Planning and Environment Court. But what I found so interesting about that report was it really showed the mountain of development applications that don't get into the Planning and Environment Court. So like if we look at Queensland, which is the top row, in 2008-2009 there were 23 development applications in Queensland, of which 591 were appealed. That's only 2.5% of the total DAs. So now, even if you assume that lawyers got involved in all of the appeals, that's still like 97% that may well have only been dealt with by, say, town planners. Like there's a lot of development applications that a town planning firm would do. You don't need lawyers, it's pretty basic, someone's applying to develop 6 units from a house block in Brisbane. You've done 500 of these applications before. You don't need to involve lawyers. You look at the planning scheme, you know what the codes say, you put together an application, you lodge it, it goes to Brisbane City Council. In their development assessment teams, there might be a town planner, there might be a biodiversity officer, they might, they work in their teams. Typically they don't have a lawyer in those teams, and that, if it's a pretty standard application, it typically doesn't get looked at by lawyers. So the vast bulk of development applications don't get looked at by lawyers. Of the ones that get to the Planning and Environment Court, most settle. So you see that the jump down from 591 to 96, that's the number of reported decisions that year. That's because a lot of people lodge a planning appeal just to maintain your rights, and then you go and negotiate with council to work it out, and most, about 80% of appeals in the Planning and Environment Court are resolved by consent. But so 91 decisions, or about 0.5% actually go on to contested decisions. And then of that, only about 10 in that year went on to the Court of Appeal and none went on to the High Court. Yet, when we as lawyers look at statutory interpretation books, we're typically looking at the Court of Appeal decisions of the High Court. And the point that I would make is, you need to do that if you're a lawyer, but the vast bulk of these things were dealt with by non-lawyers applying really basic skills. They didn't have complicated issues in them, or if they did, it wasn't contested. So I don't emphasise the Court of Appeal complex decisions, or if I did, I just think that that's inverting the actual reality. So a complicated table, but what I really want to emphasise is the vast bulk of applications are dealt with not by lawyers. And when you deal with those applications, you're doing statutory interpretation. If you're looking at a planning scheme, you're doing statutory interpretation. So, I've just shown there our court system, but there's a Planning and Environment Court. What I would just point out, I don't emphasise the complicated decisions in the Court of Appeal. Yeah, there's some really complicated planning and planning appeal decisions, but they're a real minority. So you can have confidence. Don't basically be overawed by lawyers or think that you need a lawyer to look at a planning scheme or the like. Okay, so you can solve these problems. So look, let's just look at this dam briefly. So the first step is find the law. So two really good websites. There's the Commonwealth website and the Queensland website. I've just got a screen grab of the Commonwealth website. They're all just, libraries. Get used to using them because you can just download the relevant version. And then what I typically do is open it up in, like if you have a screen that's big enough to, look at 2 pages on one as A4, you can just download it and, they're hundreds of pages long, so you don't want to print them out. Get used to using them. I just get used to using the contents page, skim read them, find the relevant bits, be aware that there's a definition, there's always going to be definitions, and so you skim read it and identify in the EPBC Act there's a series of triggers at the front. So in our case, let's just say we've skim read it, we find that in Part 3 there's a section that deals with World Heritage that says a person must not take an action that has or will have a significant impact on the World Heritage values of declared World Heritage property. Now we know for our dam the concern is pollution to the Great Barrier Reef, so that's a World Heritage property. So that is part of our facts. A person is defined in all the Acts Interpretation Acts to include not only a real person but also companies. Our client is a government-owned corporation, so it's a person for the purposes of this. Must not take an action. An action is essentially any physical activity. It's defined in section 523. We could go and look at that definition, but let's just say it's a physical activity. We're going to build a dam, we're going to do an action that has or will have or is likely to have, so probability, a significant impact. There's no definition of that. If you went and looked it up in the dictionary, you'd find it's an important and notable impact on the World Heritage properties of declared World Heritage property. But impact. And I didn't bring in section 68 of the Act, but it says in assessing whether an action requires approval, the Minister must consider all impacts of the action. So this Act sets up essentially triggers, and then if you think that you might trigger the Act, you're supposed to refer it to the Commonwealth Environment Minister, who assesses it and decides whether it's a controlled action or not. So the Minister in this case decided it wasn't a controlled action and gave a statement of reasons saying it's because there was requested a couple of statement of reasons from some conservation groups, and he said, they said, but look at all the pollution that's going to come from the farms. And the Minister said in his statement of reasons, the impacts of farmers using water from the dam is not an impact of the action that's been referred. So if you think about it from our client's perspective, is that a good interpretation? We're for the dam builder, so yeah, we don't want to be responsible for those farmers. We just want to build the dam and supply them with the water. If they happen to use it to pollute the GBR, that's not our fault. That's how we could think, and it's certainly how the Commonwealth thought of it. And essentially it involves the question then of dealing with direct and indirect impacts, and essentially I was involved in a case that went to the federal court and then to the full federal court, where the federal court just said essentially the plain meaning of impacts includes direct and indirect impacts. So if you have an action that you are contemplating others will use your product and that will cause an impact, then that is relevant to be assessed under the Act. So essentially for environmental impact in Australia, because this Act is national, the basic approach is you look at direct and indirect impacts of an activity and what's essentially the project supposed to do. And it's pretty, you might think that's a bit strange for a dam for agricultural development, but if you think about it in a couple of other contexts, we do it all the time. So if you're acting for the Department of Main Roads and you wanted to build a highway, do you think in assessing that highway you would need to assess the impacts of traffic using the highway? Put your hand up if you reckon you should do that. Yep. But from Department of Main Roads perspective, they're just building the highway. It's other people. They're not going to drive cars on it, or maybe the occasional truck, but there'll be millions of other people who will use it. Should they be responsible for the noise that other people generate? They just want to build the highway. But if you think about it, assessing a highway when the whole purpose is for traffic to come and it's going to generate noise, it would be stupid, wouldn't it? But it's really about the third-party impacts of the highway. Similarly, an airport. You know, if Brisbane Airport Corporation wants to put in another runway, should they be responsible for people landing planes on it? You know, Jetstar and Qantas and all those other, you know, bad companies want to come and land planes on their airport, and that generates noise. All they want to do is build the airport. Should they be responsible for the noise? Do you think they should? Of course. Like, it would be stupid to build an airport and not assess the impacts of the planes, but the planes aren't, you know, they're not run by the person that builds the airport. And similarly, a shopping centre, should you assess traffic? Of course you should, even though the shopping centre proponent just built the shopping centre and then all these thousands of people wanted to drive their cars there. But of course, if you didn't assess the traffic impacts of the shopping centre, you'd have a bloody bad development and, you know, a bad approval, because you'd have all these traffic snarls at the, you know, people trying to get in. So of course you assess the traffic. And a coal mine, a little bit more controversial in Queensland, but if you're developing a big coal mine to sell coal for someone else to burn, logically it's an indirect impact of the development. You know, you're digging up coal for it to be burned. You can at least assess the burning of the coal in assessing the mine, and that's commonly done under the EPBC Act now. So this case was about impacts and direct and indirect impacts, but if you think about it in other contexts, it's really quite logical. So impacts, all we were doing was applying the plain meaning of impacts. That impacts, if you look it up in the dictionary, it typically includes the direct and indirect impacts, not just direct cause and effect. So that led, the litigation around this led the Commonwealth government to amend the Act to include this really, really complicated definition of impacts, but it basically means the same thing, that when an impact includes the direct and indirect impacts of an action. So those are the three basic steps. I don't want to spend more time on them. It's just wanted to introduce them. So identify the relevant legislation and any related documents, skim read it, identify the relevant bits. I used to have a fourth optional step that I talk to students about, but I deleted it from your version because I actually think what I've done on the final page is that what I'd emphasise to you is recognise your limits. So allow for more difficult cases, that if something's unclear, recognise it, and if it's important because your client risks prosecution or there's major costs and delays if you get it wrong, then seek professional legal advice. I'm not just saying that as a cop-out to generate work for lawyers. I'm saying that the bulk of your work you should be able to do without lawyers, but obviously there is a role for lawyers. If it's a really, you know, you look at something and you can't work it out, you ask your manager and they can't work it out, you consult within your team, no one really knows the answer, and it's a big deal because if you don't have this, you know, you're wondering, do we need this approval or not? And if you don't get that approval, they might be prosecuted, there might be all these delays with your project. You know, well, that's the sort of situation when I'd say, red flag coming up here, go and get some legal advice, and, you know, there's big consequences with it. But recognise that, but you can do the bulk. Okay, so are any applications needed to gain government approval? Here, if we just thought about that one trigger for the EPBC Act, this is massive dam, massive agricultural development. Do you think it would cause a significant impact on the Great Barrier Reef? Maybe. It's in that ballpark. Ultimately, the minister reconsidered it and said it was a controlled action and needed to be assessed. A second dam was proposed. Ultimately, the farm development never went ahead, and a second version of the Nathan Dam got proposed to supply water for mines, and that got approved late last year. So yeah, it took ages to get through, but the key question for us is, well, yes, this trigger, we've identified that there's this trigger that, you know, is important and there'd be real world consequences for our client. It's the sort of thing where we should probably be making an application under the EPBC Act and let the minister decide whether we need to go through the approval process or not. So, can I wrap up? wanted to focus on two basic skills: how you think about environmental law, and then the most important skill that you need working in it is statutory interpretation. And the key thing I wanted to emphasise with that second one is you can have confidence to do a lot of things in environmental law. You don't need lawyers to do most of those things, but obviously lawyers have a role. I'd really value if you have a look at the synopsis book when Alex will email it out. Have a look at any areas you're familiar with. Give us some feedback if you think it's a good summary or not. Would love to hear from you. I find it's often really difficult to identify for a lot of the small bits of legislation who administers it and whether there's any good websites and those sorts of things. There's so much information out there, so it's meant to be drawing together best websites and the like. So if you look at it and you think there's something I've missed, I'd love to hear from you. So to wrap up, we looked at the that's not Paradise Dam, another big dam I worked on a lot, Nathan Dam, and asked the question, does the dam comply with the law, or what steps do we need to take to make it comply? And then within that we unpacked how do we conceptualise the law, how do we interpret the law. We focused on the EPBSAC, but there'd be all these state level approvals as well in the real world. And this is a key message I want you to take away, apart from the conceptualisation, is you need to be able to navigate multiple large overlapping apps and related documents at the same time. If you can do that, then you can do so much in your professional careers. You don't need to drag a lawyer around with you to every meeting. You can have confidence to go in, look at the Act, read it, find the related documents, read it, think about it logically, look at the definition section, and you should be able to come up with the right answer. Thank you very much, and I'm happy to take any questions if you've got any questions. Or if I've stunned you all into silence, then yes.
I've just got a question with the two links that you're referring to. There was the federal and state. I just didn't get a chance to write down the state one.
Yeah, it's just legislation.qld.gov.au. Office of Parliamentary Council website. It's a fantastic resource. So, have you got that now?
Yes.
Yep, cool.
Yeah, no, that's all good.
I just have a question about when you're interpreting law and you're going through and you've got a problem, you're trying to solve it, it's just kind of like driving you around in circles.
Yep.
You sort of identify that there's a bit that maybe your problem isn't covered in. What's your recommended go-to step for that?
Sorry, you're looking at legislation.
Yeah, and you're going through trying to figure out where your problem sits and what it's triggering and kind of what the exemptions are and things like that, say veg clearing or something like that.
Yep.
And then you realise that your particular problem doesn't actually fit in anywhere. Let's call it Reg C.
Yep. And are you acting for a developer or are you acting for a council or?
For a developer.
So typically the approach I take is, if in doubt, err on the side of making an application or talking with government about it. So often, obviously, you can have pre-lodgement meetings with different, say it's in Brisbane City Council area, you'd have a pre-lodgement meeting with them. You've got your application together, there's bits that you're unsure how they will react to it, so you might go off and have a pre-lodgement meeting with them. My experiences don't expect government to understand its own laws, but it's if you go to them and present them with the issues and say, I'm looking at this policy and I'm just not sure what we're required to do here, and identify those sorts of things, then you can get some, in that sort of circumstance, I would be trying to get, bounce off them what they think. My general approach is, if you're unsure, err on the side of making an application up front, or trying to resolve it conclusively. There are things that are actually difficult to work out, and you might, you can logically be uncertain about them. Anyone else got ideas on that? Olivia, what do you do if you're uncertain in your planning practice? So Olivia's with Hopwood Gannon in the planning section. So what do you do if you're uncertain about whether an act or approval is required.
I suppose just you're looking at all your instruments sort of reached and in parts. I'd start turning to specific research decisions. Let's see if someone else has had to think about this before they put decisions on it. Are there other similar decisions on the online or control actions? See how other people dealt with it. Knowing there's limitations with the things different factually, but they're the sorts of things I'd use to sort of see if someone else has had to think about it.
Yep, so Olivia's saying, go and look see if someone else has dealt with it, and maybe look for some court decisions or the like on it. That isn't part of the stages I've discussed, because I used to have a fourth step of, go and look for court decisions, but the more I am involved in courts and applying court decisions, the more difficult it becomes, because it's actually a whole skill set to actually understand whether a court decision, what it actually means, and whether it's actually binding, or whether it's a good decision that you can use. And I just think if it's a important problem for you to solve, then that's probably where you consult with the manager and potentially engage lawyers to ask. If you can't work it out though, the answer you'll probably get from lawyers is, we're not quite sure. Because often they won't be sure. And typically when you're in litigation, the only things that go on to a decision in court is where there is a legitimate fight over something, where there are two arguable sides or more, and the two sides assemble it. And you might have or a team of great lawyers arguing for what seem like completely incompatible interpretations of the same basic words, and they can spend days fighting over it, and no one can really tell you what the answer is going to be until the Court of Appeal has decided it. But that's a really rare case. So I was also just thinking, often I come across that sort of problem when you're looking at planning schemes, and trying to work out what use you've got, like the definitions, those sorts of things, is often where you look at it and you go, oh, are we is this a X use or is this a Y use? And I'm not quite sure, and it might make a difference between it being impact assessable or code assessable. And if you're preparing a development application, you might try and change your application so that it falls into the code accessible category. So you modify what you're doing to be on the good side of that split. But those sorts of things can be really hard to resolve. Yep.
I was just going to say, I work in state government, and I spend a lot of my time responding to questions like, "Hi, please find attached massive document. Do I need a license?" And what I can definitely say is we respond, but to make it easy and a more kind of easy way to get a good response back is just be like, this is the project we're looking at, this is the kind of clearing, say, for protected plants that's occurring. Do we fall under the Nature Conservation Act, whatever it might be? And yeah, we definitely, it's easier to, and then if you have a response back from us saying, no, have a look, all good, then that's something you can use at the tail end. If something goes wrong, you can say, I've contacted the department, they've stated here that it doesn't apply. So even if you don't get a response, it's still like, I went to you, this is what feedback you gave me. So it's, although it kind of seems like you don't want to go down that line, if you don't have to go down that line,
yeah,
and you feel like you might waste time going down that line, at least that way you're covered at the tail end of something as well.
Yeah, so great point. You work for state government. I just repeat it for everyone. So you work for state government, you often get big applications just with a massive document saying, do we need approval? And hey, you do respond to them, great. I was reminded of it's hard when you're in government to respond to things, because you're dealing with the application, and our planning systems are often built around the assumption that people know what they're doing when they apply. And when you're assessing something, you're working on the assumption normally that someone understood what is accessible development or what is that particular category, and you can pass like ships in the night because the person applying didn't understand, and the person interpreting the application might be confused about what you're actually applying for. I prosecuted for Fisheries Department a few years ago a fellow who built a marina up at Maryborough. He'd bought a development approval from someone else who gotten the application through, thought he had approval to clear the mangroves, but when he actually went back and looked at the development application, the applicant had ticked, there will be no damage to mangroves. So it never went to fisheries to be assessed because the application was, we will not damage mangroves. Then this person started misunderstanding what the approval actually did, started clearing the mangroves, got prosecuted, got fined $160,000 for it, for, well, I would say stupidity. But the actual approval had, there was this map. Anyway, don't get into. I don't need to get into the details of it beyond that. But you can. Our systems work on the basis that people understand what they're applying for, and it's often hard for decision makers. Because you're just responding. It's not your application, it's their application, and you're assessing whether to approve it or not and what conditions to. So if they haven't described what they're doing right, then you are not assessing what they're actually doing, but you don't even know it.
Question sort of on that. Given the low numbers of these decisions that go through a review or appeal process, is that indicative of a system that works well or a system that works poorly, given that there might be...
That's a great question. Given there's this small number of appeals, is that a system that works well? I think yes. And with the planning system, often, everyone gets a bit frightened by the size of planning schemes, and everyone says, oh, look at the Brisbane City or the Gold Coast planning schemes, they're so massive. But the thing with having large, complex documents that set out a lot of detail is, once you can navigate them, you've got certainty about what the local government wants for that site. Setbacks, gross floor area, heights, and all of those sorts of things. So you design your development application around that, and it might cost you several $100,000 to do all of the reports and the like to lodge your application. You don't want to spend that money. A proponent doesn't want to spend that money unless they're pretty clear they're going to get approval. So you design your application around what you know is going to be approved, or maybe you push the margins. The maximum height is 10 stories, and you think we might get away with 12, and give good reasons for why it should be justified. But if your client wants to apply for 120 stories and the maximum height is 10, you tell them no way. It's just not going to. You'll never get approval for this. Let's not spend. Let's not waste our time on it. So what is expected. You can prepare your development application, lodge it, and local government or whatever regulator can assess it on that basis. So that's why a lot of things get approved, because people have framed their applications around what they know is required. The low number of relatively of appeals, I think, is indicative of a system that's working efficiently. Others would disagree. They would look at 500 appeals to the Planning and Environment Court. That's outrageous, but that's in the context of 20,000 odd development applications, and people often miss that broader context. Any other questions? I know we've gone about an hour now, and there is some alcohol and food waiting at the back. If there's no more questions, then I'll wrap up. Alex, thank you very much for inviting me again, and thank you, everyone.